Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Law of Torts, we were discussing general defenses against tortious liability from my last video, and in that video series, this is my second video. In my last video, we have tried understanding briefly about what are the general defenses available with the help of lot of images, and from this video, we are going to understand each of those defenses in detail with the help of lot of case laws, and among them, the most important and the first one is Volenti Non Fit Injuria. Now, this is very important because most of the time in examination, this is an independent question. So, we need to understand this in detail, and that's why I have as many as 13 case laws for you guys. So, no need to go anywhere else to understand what is Volenti Non Fit Injuria. But before I get into that, I'm going to quickly show in 30 seconds the first two slides that we have discussed in my last video to recap that what we have started with. Not taking much of your time, let's get into the first slide. Well, we have already seen this slide that is on general defenses against tortious liability, and we have listed as many as 11 general defenses. Among them, the first 8 are very important, starting from Volenti Non Fit Injuria, Plaintiff the wrongdoer, inevitable accident, act of God, private defense, mistake, necessity, and statutory authority. In addition, I have also given 3 other general defenses, that is act of the state, parent having parental or quasi-parental authority, and acts causing slight harm. We are going to understand all of these one by one, but for now, the focus is completely on Volenti Non Fit Injuria. Volenti Non Fit Injuria. I have already shown this slide, and we all by now know that whenever the plaintiff has given consent to go through certain amount of harm, and if he or she experiences that there will not be any legal compensation available them, that is what known as Volenti Non Fit Injuria, or the plaintiff cannot sue defendant in certain case where there is already consent given by the plaintiff. While it looks quite easy, it's not that easy. We have to understand this particular concept in detail, and that's why we have a lot of slides waiting for us. And let's start from my next slide to understand the concept and then get into case laws. So here is the slide where we are going to understand the concept of Volenti Non Fit Injuria. The concept Volenti Non Fit Injuria is also known as defense of consent, because there the consent of the plaintiff is available and that becomes the defense to the defendant, or it is also known as leave and license, because somebody has left their right or given license to whatever is going to happen. That is why this is called in that name also. Now, the term Volenti Non Fit Injuria is coming from Latin legal maxim, and the meaning of the same is to a willing person it is not a wrong, because you have willingly left your right, or you have willingly agreed to go through some harm, or you have given license to someone on something which is going to cause certain amount of damages to you. Even that case you have agreed, that way you have left your right, so it is not wrong from the defendant side. That's what we are going to understand the things here. The 4 major ingredients that you should always remember in Volenti Non Fit Injuria is: the first one, plaintiff knows the risk, or plaintiff know the outcome of the act that he or she is going to do. And secondly, plaintiff voluntarily agrees to do the same. Here the consent is not forced, or there is no kind of cheating, etc. The plaintiff has voluntarily agrees to go through it, where he or she is aware that they might suffer certain amount of harm. And the third ingredient is the plaintiff experiences injury. When I say injury, it is legal injury. And the last one, in that case, there is no damages or compensation available with the plaintiff. So the first one, plaintiff know the risk. Second one, he voluntarily agrees to take the risk. The third one, he or she experiences the legal injury. And the last one, in such case, there is no damages or compensation available to the plaintiff. That's all you need to remember as far as the ingredients are concerned. Well, after listening so much, now you might be feeling that I have understood what is Volenti Non Fit Injuria. Yeah, it looks quite easy, but it's not the end. we have to understand it with the help of illustrations, and then later we have to discuss this with the help of case laws which are supporting what is volenti non fit injuria, and those factors which are conflicting or bringing contradictory or bringing some confusion, all of that we need to understand with the help of case law so that we know the concept completely. Let's get into the illustrations. Now I have brought few torts like trespass, defamation, battery, all of that. Let us try understand one by one and try see how exactly volenti non fit injuria sits in these examples. The first one, you are inviting few guests to your home and they are coming into your house, and after you giving consent to them to enter your house, now you cannot put a case against them saying that they have trespassed. Okay, here volenti non fit injuria, you have given consent to someone to enter your home, so you know that they are coming into your house because you yourself have given consent to them to enter your home. Now you cannot sue them saying that they have trespassed. Okay, that's what you need to understand. The second one, you are going through a surgery or your family member has to go through a surgery for which you have given consent to the doctor to do the surgery, and later you can't sue the surgeon because you have already given consent. You know that there are certain amount of risk. Now you cannot ask for compensation after the surgery. Okay, that's the second one. Third one, you have agreed with the publisher that you can publish certain amount of information about you. Now whatever content you have given to the publisher has published the same in the newspaper or whichever publication he has. Now after he publishing that, you cannot sue that publisher for defamation because you yourself have given consent on the material or the content. Now where while giving the content itself, you should know what is the outcome of the same. You have given consent to the content. Now you cannot put defamation case against the publisher. That's about the third example. In the fourth image, you are seeing a boxing competition. Now here, when somebody is participating in boxing, they all know that the person who is competing against him can hit on certain places and he or she can experience certain amount of injury. Now this comes to a physical injury, and here after getting such injury or the punch on the face etc., he or she cannot sue the opponent saying that they have caused battery or in Indian context assault etc. Now that's not possible because the game itself is so. There are certain amount of rules and there are certain amount of opportunity with each opponents or competents. So there is no case saying that he or she caused me some hurt or injury. That's about the fourth illustration. The fifth one, you are going to watch a cricket match. Now if the ball comes and hits you while watching the match, you cannot sue the batsman or the board or the people who have organized the game because you have given consent by buying the ticket or entering to the stadium. Now these are the few examples you need to keep in your mind. Well, now if you are thinking, yeah, this is all, that's not the end. Now let's get into that yellow box where I have mentioned few important conditions. Now discussing about the second illustration, I explained that if you have given consent for the surgery, now later you cannot sue the doctor for the whatever thing has happened as an outcome. But saying so, that is not the end. Doctor need to perform his or her duty very carefully, diligently. If there is negligence from the side of the doctor, then that becomes a tort, that is negligence. Likewise, in the fourth image, we discussed about boxing. If a person hits to the place where it is not allowed or out of the game, out of the rules, in that case, there is always a case possible for the hurt. So, following the rules or following the duty very diligently and not showing negligence is one of the very important thing or one of the major condition to consider that the plaintiff has given consent. That is very important. While saying consent, the second condition comes into picture. What is that? Consent must be free. if the consent is taken by fraud or if the consent is taken by compulsion, etc., in that case that is excluded. Okay, that will not become a defense for the defendant. Now that's about the consent part. And the third one, mere knowledge doesn't imply assent. That means I know there is certain amount of risk, that itself will not make sure that the plaintiff has given the consent for the act by the defendant. Now there needs to be acceptance, there need to be agreement, there needs to be approval by the plaintiff. Only in that case the defendant has the defense of volenti non fit injuria. Mere knowledge doesn't imply assent, and on that we are going to discuss with case laws also. Whatever we have discussed here, this is not the end, this is just the start, because we have as many as 13 case laws to clarify all of that. Initially, let us start with those case laws which are supporting the principle, that is volenti non fit injuria, and then later we will get into little bit of complicated case laws. The easier first and the difficult later. So let's get into the case laws world from my next slide. The first case law that we are discussing here is Hall versus Brooklands Auto Racing Club. What happened here? Brooklands Auto Racing Club organized a race competition and Hall bought a ticket and went to watch the race. Now in the race there was collision happened between two cars, and as a result of that collision one car entered to the spectator's place and Hall got injured because of that accident. Now here Hall put a case against Brooklands Auto Racing Club, but the court said yes, Hall got injured, but by buying the ticket there was a consent, which is an implied consent to the risk which is going to come as a result of any accident which is going to happen due to that particular race. There the court said Brooklands Auto Racing Club can use the defense of volenti non fit injuria. The second case law that we are discussing here is Padmavati versus Duganaika. What are the facts of the case? There was a jeep driver by name Mohiddin. He was passing through on a road. Now while he was going there, two strangers stopped the jeep and asked lift. Now what Mohiddin thought, okay, there is no other vehicle coming for them, so he thought of giving lift to them. While going, the jeep got toppled because of some issues with the jeep and one of the passenger died. Now that passenger's wife Padmavati put a case against the owner of the jeep, Duganaika. Now the court said the driver was neither rash nor negligent, and the strangers by asking lift in the jeep have given consent to accident, etc. Now if there was certain amount of rash or negligent, etc., it would have come on the owner of the jeep and the driver also. But here, as there was nothing like that and whatever happened was an accident, there is no compensation available, and the court said here the strangers by boarding the jeep have given consent to whatever happening, so there is no compensation available. That's the second case law you can think for the volenti non fit injuria concept. The third case law that we are going to discuss is about horse race. We are going to discuss a lot of case laws related to horses here. The first among them is Woolridge versus Sumner. What happened here? A photographer went to watch the horse race and he wanted to take some beautiful picture. So he takes certain amount of risk by positioning himself in a location where there was certain amount of risk available. Now Woolridge wanted to capture some good photos, so he took the risk and a horse in the process of the race hit him. Now the horse rider haven't ride it recklessly or deliberately. You should know that horse race is a quick competition where every rider wants to take his horse as early as possible to the ribbon and want to win the race, and in the process this particular incident happened. Now Woolridge put a case against the horse owner, that is Sumner, but the court said by doing such arrangement of sitting in a particular place and taking the photographs, the photographer knows that there is certain amount of risk is available and the rider has not ridden the horse recklessly or deliberately, so there is no matter of compensation arises, as there is a case of volenti non fit injuria, or the plaintiff has given consent by doing the act that he has done, so that way the defendant has no liability to pay any kind of compensation because nothing here was controllable to him. So that's what the court held here in the case of Woodridge versus Sumner. After discussing three simple case laws, now let's getting into another very important topic, that is how important is a notice on the risk available in doing so and so activity. Like for example, here I am discussing two important activities on trespassers. About putting notice is important and what happens if there is no notice available. The first case law that we are understanding is Illert versus Wikes. Here what happens, Wikes has certain amount of land and he has put spring guns in his land, and Illert was aware that there are spring guns available in the land of Wikes. So though Illert was aware that Wikes has put certain amount of spring guns in his land and there are risks available, Illert decides to trespass into the land of Wikes. Now, getting into the land of Wikes, Illert was very clearly aware that he is exposing himself to the risk of spring guns, and even after being aware of that, if he is trespassing and he later got injured also, the court said there is nothing as compensation here because Illert by his act has given consent to the risk that he is going to take because there was already awareness available with Illert or the plaintiff that there are spring guns available in the land of Wikes. So court held as there was notice or as the plaintiff was already aware about the spring guns, there is no matter of compensation whatsoever. But the second case law, that is Bird versus Holbrook, is very interesting. Here what happened, Holbrook, the defendant of the case, had tulip flower garden, and recently somebody robbed tulip flowers from his garden, and to prevent further acts like that, he put spring guns in his land. Now Bird enters to the land of Holbrook and there was no notice available and Bird got injured because of the spring guns. Here the court said it is very necessary, yes there is trespass, but the further injury on the trespasser becomes the liability of the defendant, because if they have put something like spring guns etc., they need to put the notice so that nobody takes the risk of getting into the land of the defendant. So that's what it was held by the court. Putting notice is very important. If there is no notice available, in that case the Volenti Non Fit Injuria will not applicable. Instead the defendant has to pay compensation to the plaintiff. That is what held in Bird versus Holbrook. So basically in Illert versus Wikes, there was no compensation available because Illert was aware, whereas in Bird versus Holbrook, there was compensation from Holbrook to Bird because there was no notice available and Bird was not aware about the spring gun. That is why, so we have to see, whenever we are keeping risk, we also need to keep the notice. If we are having dog which is dangerous, we have to put a notice that beware of dogs. That's what we see in most of the homes. So that is very necessary. That notice is one of the important essential required from the side of the plaintiff so that he or she can use the defense of Volenti Non Fit Injuria, because the consent is available from the plaintiff while taking the risk even after being aware of the risk in the part of plaintiff. That is what we need to understand with the help of these two case laws. The heart of Volenti Non Fit Injuria is free consent. Here free consent is must, and that's why I am giving few very important case laws to you guys so that you have very clear idea as to what is free consent. The first case law that I am discussing here is Lakshmi Rajan versus Malar Hospitals Limited. Now this discusses about the scope of the consent. Here what happens, a lady goes through a lump on breast surgery. Okay. Now there was consent given for the surgery of lump on breast. But while doing the surgery, doctor also removed the uterus. Now for this surgery, which is surgery of lump on breast, for that there was no requirement of removal of uterus and there was no consent by the plaintiff or Lakshmi Rajan to remove the uterus, or there was no information from the doctor as to they are going to remove the uterus in the process of surgery of lump on breast. Now doctor removed, and after Lakshmi Rajan has put a case against this particular hospital, and the court said as there was no requirement to remove the uterus or there was no consent by the plaintiff to remove the uterus, the hospital has to pay the compensation to the plaintiff. Now one more very important thing you need to remember. In the process of surgery, if there is something very critical happens, and as a part of surgery, if doctors have to take some decision for the goodwill of the patient, that is another scenario. But here there was no need to remove the uterus for the surgery of lump on breast. In that particular case, that was the situation, and as there was no necessity, and even then defendant has done something without the consent of the plaintiff, the defendant had to pay compensation to Lakshmi Rajan for whatever loss she has gone through, because the hospital has gone over and above the scope of the consent that Lakshmi Rajan has given. So that's what you need to understand from the first case law. The second case law, that is R versus Williams, is again a very interesting case law, that is consent obtained by fraud. There was a music teacher who had a minor student. The age of the student was 16 years, and the music teacher told if she has sex with him, she will get very good voice. Okay. Now the student thought that the teacher must be truthful, so she has given consent, and with that consent the teacher had sex with the student. Now here the teacher tricked the minor student for sex, and the court said this is not free consent, but this is consent obtained by fraud, and hence the fraudulent consent which is being taken by the teacher was to be punished, and accordingly the judgment came in favor of the student and the teacher got convicted. While we discuss about consent obtained by fraud as an exception to Volenti Non Fit Injuria, we also should know few other things which are not considered, like consent obtained under compulsion. You are making compulsory by some situation to do or agree for something, that is not considered as free consent, that becomes compulsion. Likewise, consent in fiduciary relationship like father son, teacher student, master servant, all of these are consent in fiduciary relationship where the person who is taking consent is in the higher position or beneficiary position or a leadership position, which makes the other one to give consent. That is also an exception for Volenti Non Fit Injuria. Likewise, consent by minors, we have already discussed R versus Williams case also, where there is fraud as well as minor cases available. Then consent for illegal acts like drug, etc. All of these things are not considered. I hope that gives a lot of clarity as to what are not considered. Now I am coming to the last part of this slide, where I am discussing about rescue acts with the help of two very interesting horse stories. Now in rescue acts, as of very nature, whoever is going to rescue, there will not be any kind of time to give consent, etc. Usually to save property or to save person, people gets into action quickly to rescue some property or the people involved there. Except for those invitations to the fire agency, etc. after seeing some fire and people are calling, there is a lot of time. But in most of the rescue cases, it happens instantly. There are two horse stories. Let's discuss what happened here. The first one is Hayes versus Harwood. What happened here? Harwood had two horses and he tied those two horses to a van in a very busy street. Now there were so many people, there was so much of atmosphere, and few people thrown stone to these horses. There are always people who do nonsense things or whatever you call. Now because of that act by these people, horses started behaving crazy. When people behave crazy, it is not a thing that we can negate that horses can do crazy things. They started moving here and there, and there was a lot of havoc, and suddenly Haynes get into the picture. Now who is Haynes? Haynes is a police officer. Now as part of his duty is also it is his responsibility to protect the people, and more and above it is a risky situation where he had to take control over the horses, and in the process Haynes got injured. Now, after that, Haynes put a case against Harwood, and the court said that Harwood has to pay the compensation to Haynes, because though there was no invite to Haynes to get into this action, it is a rescue act where Haynes was trying to protect few people, and as a nature of his job also it was a requirement to do so. So the plaintiff had to pay compensation, though there was risk involved, and Haynes was very much aware of those risks. He has given consent to take those risks. Even after all of that, as it is a rescue act, the defendant had to pay compensation to the plaintiff. That is the first story. What happens in the second story is very interesting, which is the other side of the horse story. What happened here? United Dairies had certain horses in their campus, and Cutler saw them, they doing little crazy behavior, and he wanted to calm down them, and in the process Cutler got injured. Now the court said there was no need to Cutler to calm those horses, because there was no risk to any property or people immediately, and he unnecessarily got into that action. That's why United Dairies, the defendant, need not to give any compensation to the plaintiff, that is Cutler, which is what held in the Cutler versus United Dairies case law. So this is what you need to understand. In rescue acts, if you are getting into some action for protecting property or people, in that case there is no consent or your permission is required. You can get into the action with free consent, and later if something happens, the case will be seen in a different way. On the other hand, where there is no necessary, don't get into that act, because court will not support you for such acts, which is what very clear in the case law of Cutler versus United Dairies. While discussing Volenti Non Fit Injuria, one another concept that you need to know or you should know is Volenti Non Fit Injuria, or mere knowledge of the risk isn't enough to claim defense. Just because somebody knows there is a risk, and even after knowing that risk, if they are agreeing to do something, that doesn't mean that they have agreed for the danger also. In these cases, Volenti Non Fit Injuria, whatever happens to the plaintiff, the defendant has to pay compensation, and for that we have two very interesting case laws. The first one is Boater versus Rowley Regis Corporation. Here a municipal corporation asked one of its employee to use a particular horse with the cart, and this horse was known for all not good things, or it was doing certain amount of acts which was danger to the person who was riding the horse cart. And here Boater disagreed to take that horse, but the corporation forced him to use it, and he got injury in one of the incident which happened later. And here when he put a case against the Rowley Regis Corporation, the court said that the employee was already aware that there is risk, and he brought it to the notice of the corporation. Though corporation was aware about the two incidents which happened early, they forced him to use that horse with the cart. And whatever happened to Boater, now this is not Volenti Non Fit Injuria. Though he has awareness of the risk, he never gave consent, and hence Rowley Regis Corporation have to give compensation to its employee. This is coming under Volenti Non Fit Injuria. Mere knowledge of the risk isn't enough to claim defense. Yes, the employee was aware, and he has brought to the notice of the employer, and employer was not ready to give him a good horse, and hence this happened, and hence the defendant is liable to pay compensation to the plaintiff, which is what held in this particular case law. Similar story goes with Smith versus Baker and Sons case, where an employee who was working for railway company, that is Smith, he was aware that while doing his work there is always a risk from the crane which is passing stones on his head, and in one of the accident a stone fell down and he got injured, and Baker and Sons tried to prove that Smith was aware about the risk and he has given consent, but the court said yes, Smith was aware of the risk involved in the job, but he never given consent to die because of stone felling or getting injury because of stone felling, all of that, and the employer has to give compensation to the employee, which is what held in this particular case law. So by Boter versus Rowley Regis Corporation and Smith versus Baker and Sons, we need to understand mere knowledge of the risk isn't enough to claim defense or Volenti Non Fit Injuria. Here, these are the very important things that we need to keep in our mind. Due to time constraint, I am not getting into the details of all these case laws, and I request you guys to read through these slides because these are very important. I am bringing in the citations, facts, and what is held in the case law, all of that. This is coming after a lot of efforts, and I feel not so good not explaining all of these things, but time is also a very important thing. I know you guys are looking at these slides at the last moment or before the exam, so I don't want to kill all your time, but if you are interested and it is a requirement to go through all the facts and understand what is held in the court, so possibly read as much as possible so that it gives a clear dimension as to what is the case law all about. Okay, now let's get into another very important aspect under Volenti Non Fit Injuria. Guys, don't get confused here. While we discuss about the general defenses, the second defense that we are going to discuss is plaintiff the wrongdoer. Here in this slide also you are seeing when plaintiff the wrongdoer, but this is not in the context of that general defense, but under Volenti Non Fit Injuria, if plaintiff is a wrongdoer, how exactly we are seeing is what we are going to understand with this particular case law, that is Thomas versus Quatermain. Here the plaintiff, that is Thomas, was an employee in a brewery of defendant. Now one day while he was working there, he tried to remove the lid of a boiling tank of water. The lid was so tough to remove, but he put all his extra power to remove the lid. While he generated so much of force, the extra pull threw him in another container which contained boiling liquid, and because of that he had to suffer from some serious injuries. Now he put a case against his employer or Quatermain, but the court held that as there was awareness as well as visibility of risk, no damages to be paid, or this is over and extra activity that the employee or plaintiff or Thomas has done. He could have always gone for the support of other employees, or he could have stopped it because it was already very risky to do so, and he was working in an atmosphere where there was a lot of danger was involved, and the employer has not asked him to do such activities. So here the court said there is no compensation whatsoever to the plaintiff. From the previous case, now that we have understood that when the plaintiff is wrongdoer, there is no compensation available to the plaintiff. But on the other hand, what if the defendant is negligent, which is what we are going to understand from Slater versus Clay Cross Company Limited. What happened here? There was a railway tunnel and public was using that railway tunnel as a shortcut. Most of the time public used to use that tunnel as a shortcut, and one day while plaintiff was passing through that tunnel, a train come without any kind of honk etc. So the plaintiff was not aware the train has come and the accident happened and he got injured, and he put a case against the Clay Cross Company. Now the court held that yes, public were aware that there is danger available by using that tunnel as the shortcut, and just like any other public, Slater could have taken sufficient precautions. However, there is negligence from the railway company by not honking. If the train driver, if at all, if he had honked, Slater could have taken more precautions so that this accident could have been avoided. But because of the negligence of the train driver, the entire episode happened, and that is why the railway company or the defendant is liable to pay compensation to slater or the plaintiff, which is what held in this particular case law. Now, before I hand over this presentation to Nishan, I know this has gone little lengthy, but remember, this is the most repeated question whenever you are writing exam on law of tort or for any competitive exams like CLAT, etc. All these case laws which I have discussed here becomes very important because questions can be framed anyway and each of these case laws can be a problem. That's why understand them very clearly. If required, go through them again, and as I have already told, please read through the case laws which are very clearly given in this slide. I have not explained each and everything because of time constraint, but I request you all to go through the content that I have given in each slide, and with that I am handing over this presentation to Nishan.
So that's about Volenti Non Fit Injuria. If you decide to hit yourself with a hammer, nobody is going to give compensation. That's it. With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.